Recording in progress.
Honorable members, I hope I'm audible.
Yes, Chair, we can hear you.
Thank you. May I just check what if we've got what to proceed? Committee Secretary, may I just check if we've got the required number to proceed? It's now 9 o'clock.
Yes, Chair, I was just counting. Yes, Chair, we have enough. We've got 5 members. At least we can start, Chair, for now.
Thank you. Greetings, honorable members. I also see that we are also joined by leadership of the department, including Deputy Minister Mazinga Shabalala, on the platform, so that we also you, the ADG in the administration, civil society structures, so organized labor is one of our stakeholders taking interest in this regard. So we recognize you. Would also recognize the representatives from the Parliament side that are on the platform, from the Constitutional and Legal Services Office, CLSO, and those would be Ms. Williams, Ms. Halley, and Ms. van der Merwe that are on the platform. Fellow South Africans who are taking interest in the deliberations of this committee, following us from platforms made possible by Parliament. Honorable members, I would, without waste of time, having confirmed that we do have the numbers to start the meeting, and surely that would also improve as we move forward. Let me then, at least for purposes of helping us, to just remind ourselves on how we conduct meetings on this platform. This is a committee meeting of employment and labor in the National Assembly, and therefore convenes in terms of the rules of the National Assembly, especially meetings held on this platform. We are all reminded, those that are on the call, to at all times keep our mics muted, video camera switched off until at the time when you're recognized by the chairperson. At that point, you will then, having been recognized by the chairperson, unmute your mic and switch on your video camera and proceed to speak. In a situation where you are experiencing network or connectivity challenges, just ask for the permission of the chair to switch off your video camera so as to maximize your bandwidth and proceed to speak. From time to time, there may be those that lose connectivity. Just ensure at all times as you reconnect to the meeting that your video camera is off and your mic is muted, as mics are sensitive and could pick up background sounds like it is the case now. So just make sure that that happens. Point of orders are allowed in terms of the rules of the National Assembly, on which the chairperson could still rule upon. Honorable members, we are then reminded that we should be able to make it a point that we do not raise unnecessary point of orders to a point of collapsing the meeting on this platform. Having raised that, honorable members, let me ask the committee support to indicate if there are formal apologies that have been received. I can't hear committee support. Committee secretary, are there apologies that have been received?
I haven't received any apology. Thank you, Chair.
Please indicate if you've lost me, because it seems there's a bit of delay between what I raise and the response I get.
Can you hear me, Chair? Are you able to hear me?
Yes, I can hear you.
Or I was saying, Chair, no, I haven't received any apology, Chair.
Okay, with the no apologies that have been received, let me then proceed to officially open this meeting. Of course, as I do that, committee support would flight again the agenda so as to help also members of the public that are following our deliberations. As I open, honorable members, you would have seen that we would have asked for this meeting on the basis that the members would be able to be briefed on the items that are before us. But as I do that, let me also indicate, just from a point of official information, that other members that may have not been seen in the meeting, others would have been health reasons. Honorable Mukwili, we welcome you back. I saw you putting something on the chat that you can hear the chair. Of course, the committee would have been concerned and look up to in our prayers, and we're happy that you are back to participate in this work that you really are committed to do at all times. Please welcome back. We are happy. We are strong. We are on the platform now. We have also, honorable members, been informed that the MK party would have put up a member to the space of Honorable Slepe, who is probably discharged from the committee. And I was then informed that there would be Honorable Shezi. I'm not sure if Honorable Shezi is already on the platform or not. But if he's on the platform, we'll just get an indication when he raises his hand, and we'll allow him to switch on the video camera so as to be able to see him. You will correct me, committee support, if I'm making a mistake in terms of the names that one would have received. But as honorable members would be aware, also from the side of the Patriotic Alliance, we no longer have Honorable Rogue, and I was also made to understand that that replacement would have been done. So that I'm trying to check if I'll be able to identify the name, but the committee support would indicate too if that
Honorable Passon, Chair. Honorable
is
Passon.
on the platform or not. If Honorable Passon is also on the platform, like I said, you can just raise your hand so that we allow you to switch on your video camera if you are in a space to do so, just for the members to also see that the new member, and we can then relate to the member even when we see each other in the house belonging to the same committee. Honorable Passon, are you able to switch on your video camera? You are.
Thank you very much, Chairperson. Unable, my video camera doesn't want to switch on. My signal is a bit low on this side.
Okay.
IT support is busy checking it out for me, but I am audible and I can hear you. Thank you very much for welcoming me, sir. I appreciate it.
All right. Thank you, honorable members. As I said, you're all welcomed. And of course, I can indicate that this is a very vibrant committee, but to pride ourselves that we do so in a way that allows every member to participate within the decorum of what is expected in meetings of parliamentarians. Honorable members, as I said, having welcomed these members, just to indicate that our committee meeting is happening at a time when we are also busy with budget votes, of which a number of our members participate in those different budget votes. But we thought that we shouldn't postpone this matter as it relates to legislation, but also it was informed by the availability from the side of the Constitutional and Legal Unit of Parliament, as they were not available for the previous portfolio committee. So we thought we should have this, and I'm sure members would have seen quite short presentations to be made, and we think we'll still be able to release you as all budget votes are physical sittings. So for those who are participating, they'll be expected to be there physically. Honorable members, I also just thought before I would hand over to the team that I've mentioned before, and they've arranged on how they are going to approach the presentation. It's really to remind members that right from the inductions, we would have had an opportunity to interact with both the department and NEDLAC. And were informed right in the beginning that there are pieces of legislation, including the one that's before us, that are undergoing amendments to make it a point that they make sense in the current conditions, and that the process would have been from NEDLAC to cabinet and come this one. And it is against this understanding that a briefing was also made recently that the amendments to the Employment Services Act, which is the Employment Services Amendment Bill, has been to cabinet. The National Labour Migration Policy has also been to government and now on its way to Parliament. Just hope that as there was commitment, it will be presented soonest. But the other pieces of legislation that have been undergoing amendment have not yet been presented. I'm raising this, honorable members, so that we understand the presentation to be made in that context, that there may have been these gaps that have been seen that may need to be plugged in, whether technical or not. But that as we listen to it, we do not take pressure of making a decision on the spot, but allow ourselves to also apply the mind in it, even though it may be said from the presentations we have received that the matter sounds quite technical. Sometimes the implications may be quite higher at a practical level. For that reason, even when we have the department on the platform, it helps them to get first-hand information from the presentation itself, so that at the time that we ask them to come before the committee to respond to the matters that may have been raised here, they are able to do so fully. As today, they may probably just make one reflections from direct questions that may be asked from the side of the department. But necessarily the meeting is for the committee to be briefed from the side of Parliament, so as to really tighten up our oversight work, and of course our role to make laws of the country. But we have to respect also the engagement structures and processes that are in place to get to that point. So I just thought it's important that honorable members, I foreground the presentation in that way so that it facilitates the discussion much better. And I take it that with the time I've taken, it has helped the team to settle, and they will approach then the presentation in the way they would have agreed to present. I now present the opportunity for the Parliament CLSO team to present.
Good
I hope
morning.
Ms. Williams, Ms. Ali, and Ms. van der Merwe, you are able to also hear me clearly from where you are. Okay.
Yes, thank you so much, Chairperson. Can you hear me?
Quite clearly. You can proceed. Thank you.
Thank you. Honorable Chairperson and honorable members, thank you very much for this opportunity to present the Constitutional and Legal Services Office's lacuna project to you this morning. My name is Clara Williams. I'm joined in this call by the Senior Parliamentary Legal Advisor, Advocate Charmaine van der Merwe, and two of my colleagues, Sean from Radar and Talana Halistaki. Honorable Chairperson, I will now switch off my camera and then flag my presentation if this is in order. Thank you.
Thank you. Proceed.
Honorable Chairperson, can you see my screen?
Yes.
Okay, thank you so much, Honorable Chairperson. Honorable Chairperson and honorable members, my presentation will provide some background to the lacuna project, and my colleague Talana Halistaki will present on the lacuna in the Basic Conditions of Employment Act. As part of the Constitutional and Legal Services Office's mandate, we consider lacunae. These are defects or gaps in the existing law, identified by various institutions, including the Constitutional Court. We aim to empower committees to exercise increased oversight over the national executive by monitoring their initiation and preparation of legislation, so these are executive bills, and to draft committee bills. In this regard, we considered lacunae in the legislation administered by the Department of Employment and Labour. The aim of the memorandum we submitted to the Honourable Chairperson and this presentation is to advise the committee on the lacuna in the Basic Conditions of Employment Act and how it can be managed by exercising oversight over the department or by drafting legislation. With regard to the committee's oversight powers, Section 85(2)(d) of the Constitution states that the President exercises executive authority together with other members of Cabinet, the ministers, by preparing and initiating legislation. Cabinet members and deputy ministers may introduce bills in the National Assembly, and these are called executive bills. Rule 227(1) of the NA rules states that portfolio committees must maintain oversight of executive organs of state falling within its portfolio, including the department. It may monitor, investigate, inquire into, and make recommendations concerning any such executive organ of state, including the legislative program of such organ of state, and it may consult and liaise with any executive organ of state. Therefore, the committee has oversight powers over the department's legislative programs and their initiation and preparation of legislation. In 2009, the Independent Panel Assessment of Parliament criticised Parliament for its poor record in introducing legislation. Subsequently, Parliament created a dedicated legislative drafting capacity within the CLSO in 2013. Since then, 17 committee bills have been developed, of which 12 have been passed. It needs to be noted by the committee that it is not always possible to develop a committee bill. Factors that favour continued monitoring of the executive, in other words, the development of executive bills, or if a bill requires policy development, is contentious, or requires subject matter expertise. However, there are a number of factors that favour the drafting of a committee bill, including if the bill is likely technical in nature, with little or no policy development required, if the court provided a read-in that could be utilised, if the bill will deal with a non-contentious matter with little or no policy development required, or if the bill will deal only with issues and content affecting Parliament or the provincial legislatures. The committee has the following constitutional powers relating to the development of committee bills. Section 43A and 44(1) of the Constitution state that the National Legislative Authority is vested in Parliament. Section 55(1)(b) provides that the NA, in exercising its legislative power, may initiate or prepare legislation. These are called committee bills. Section 73(2) states that committees may introduce committee bills in the NA. The 2009 panel I referred to earlier indicated that the power of the NA through its committees to initiate legislation is a powerful tool to address policy issues and to assert its independence. It recommended capacity gaps be addressed, and appointments were subsequently made in this regard. Parliament's draft strategic plan of 2024 to 29 includes under outcome 5, impactful lawmaking, by amongst others implementing measures to enhance the drafting capacity of Parliament. The committee is therefore empowered and encouraged to initiate and prepare legislation. The Lacuna project empowers committees by bringing possible matters of the development of committee bills to the attention of the committee. My colleague will present on the lacuna identified by our office, and with regard to this lacuna, it is possible to develop a committee bill. In this regard, we recommend that the committee invites the minister to, as soon as possible, address the committee on its view on the defect, request the department to comment on the feasibility of the recommended amendment to the Basic Conditions of Employment Act, and consider whether initiating and preparing a committee bill is a viable option. If the committee decides to develop a committee bill, the committee can request permission from the House to introduce a committee bill that will correct the defect. If the committee decides on the development of a committee bill, it can send instructions to our office via email. Chairperson, with your permission, I will now hand over to my colleague to address you on the lacuna in the Basic Conditions of Employment Act. Thank you.
Thank you, Ms. Williams. You can then take the next one. We just discuss it once.
Good morning, Chairperson. Good morning, honourable members. My name is Talana Halley-Starkey, and I will be addressing the committee today on the lacuna in terms of Section 18(2)(b)(2) of the Basic Conditions of Employment Act. I will now switch off my camera and share my presentation, if that is okay with everybody. Sorry about that. Can everybody see my screen? Thank you. So as I said, honourable members, I'll be discussing Section 18(2)(b)(2) of the Basic Conditions of Employment Act. The purpose of the presentation is as follows. We will then understand Section 18(1), 2, 3, 4, and 5 of the Basic Conditions of Employment Act. I will unpack the interpretive issues, and then I will consider the legal framework therein. We will then provide clarity and a suggested amendment. So to understand section 18, 1, 2, 3, 4, 5, section 18 provides for provides for public holidays and the payment of employees for working on public holidays. Subsection 1 provides as follows, that an employee may not require an employee to work on a public holiday except in accordance with an agreement. Subsection 2 then states that if a public holiday falls on a day on which an employee would ordinarily work, an employer must pay an employee who does not work on the public holiday at least the wage that the employee would ordinarily have received for the work on that day, and B, an employee who does work on the public holiday at least double the amount referred to in paragraph A, or if it is greater, the amount referred to in paragraph A plus the amount earned by the employee for the time worked on that day. Then 3 goes on to discuss the employee working on a public holiday on which the employee would not ordinarily work and the payment of that employee. 4 then unpacks the payment of the employee for a public holiday when employee usually works, and that it must be paid, the employee must be paid on the payday. And 5 then unpacks the shift worked on by an employee. But our concern here is 18(2)(b)(2). So let's unpack the interpretive issues here. So if we provide a purposive interpretation, the purposive interpretation is as follows. An employer may not require an employee to work on a public holiday except where they agree to. And if they agree to work on a public holiday, the employee must be paid for that working day. Subsection 2 provides various scenarios for such payment. First, if the employee does not work on a public holiday, the employer must pay the employee the wage they usually receive for work. And then second, if the employee does work on the public holiday, the employer must pay the employee either at least double the wage or the usual wage plus the amount earned by the employee for the time worked on the public holiday, i.e., if this total is greater than the double wage. So the legal issue is that of interpretation, in that section 18(2)(b)(2) of the Act is not clear. If we consider subparagraph 2, if it is greater, the amount referred to in paragraph A plus the amount earned by the employee for the time worked on that day. The subparagraph makes reference to the amount in paragraph A, the usual wage, but then begins the item with if it is greater, and then continues the amount referred to in A plus the amount earned by the employee. The confusion then lies in the pronoun it. Questions that may arise is, which noun is it referring to? What is the greater that the section refers to? Does the subparagraph state that should the usual amount of wages earned plus any amounts earned to be greater than the double wage, that the employer should pay the employee that amount, i.e. the normal wages plus whatever earned on that day? Or is the section attempting to state something else? So, honourable members, you can see there is a syntax issue here. So if we consider the legal interpretation, there's a simple grammatical rule. The use of pronouns such as it, they, them must only be used where the noun to that pronoun refers is unmistakable. So if I can give you an example, how not to use a pronoun. In this silly example, it says, after putting the disc in the cabinet, Mabel sold it. So in this example, the pronoun does not have a clear and unmistakable noun. This results in the reader not knowing whether Mabel sold the disc or the cabinet. And this is similar in the case of 18(2)(b)(2). Such errors can confuse the reader and obscure the intended meaning. Although section 18(2)(b)(2) is faulty in syntax, there have been no interpretation issues raised by legal commentators or by any court. So the common interpretation, therefore, is that the employee either pays the employee double the normal wage or the normal wage plus any amount that is earned on the day, whichever is greater of the two. So we decided that we were going to provide clarity in terms of the syntax issues, and section 18.2b2 is technical in nature and there are no possible policy development required, but it does create semantic ambiguity. A proposed amendment would read as follows, and we've used normal drafting techniques, honourable members, and the changes in the font are in red for ease of reading. So what we've done here is we've said that subsection 2 states, if a holiday falls on the day on which an employee would ordinarily work, an employer must pay an employee who does not work on the public holiday at least the wage that the employee would ordinarily have received for the work on that day. So that remains the same. But then what we've done here is we've provided an amendment to B, which states as follows: an employee who does not work on a public holiday, and then we've included the higher amount of the following, and then we've removed at least double, and we started off the subsection with the subparagraph with double the amount referred to in A, or, and then we removed, if it is greater, the amount referred to in A plus the amount earned by the employee. And we believe that this provides a clearer and less ambiguous interpretation of section 2B2. So that concludes my presentation, honourable members, and I will leave it up to you to, if there's any questions or any issues of clarity, please direct it. Thank you.
Thank you, the CNSO team. I will then I'll be taking input. Before I do that, I just want to be sure that I saw deputy ministers here recognized, but I've explained right in the beginning that it is indeed just a briefing to the committee. We may need to still have a session with yourselves, unless there will be matters you think the committee may just need to be clarified on before we close. Otherwise, there's a process I've defined in the engagement right in the beginning. Can I get members to raise their hands? Raise their hands for noting, so that we just follow the order of speakers. Is the Honorable Willie, so Honorable Mayeso first, but your hand went down again, so that's why I went to the next speaker. But Honorable Mayeso, Honorable Mupili, Honorable Bahrain, Honorable Basson, Honorable Bele, and then the Honorable Donsal, the last, in that order, Honorable members. The Honorable Mayeso.
Thank you, Chair. Apologies because I'm having a serious network challenges here, and with your permission, Chair, I request to continue switching off the video camera.
Please proceed, Honorable Member.
Thank you, Chair. Chair, I will go straight to the presentation. And Chair, I would want to ask the team, and let's welcome the parliamentary legal team for presenting this important presentation, Chair. Now, my question will be, does the current wording of section 18 subsection 2B creates sufficient ambiguity to warrant legislative amendment. And 2 is the use of the pronoun it in the clause legally problematic or open the misinterpretation in the practice. Lastly, what is the Department of Employment and Labor interpretation of Section 18, subsection 2B? Thank you, Chair.
Thank you, Honorable Mayor. Honorable Mupeli.
Thank you very much, Chair, and greetings to everyone. And thank you for your well wishes when I was sick. I'm still not fine, Chair. But I would request that my mic be switched off because I'm still laying in the bed of the hospital. So
You are allowed to proceed, Honorable Mupeli.
thank you very much, Chair. No, man, I'm gonna just ask the presentation to whether the presenters to whether in the case where the parliamentary oversight alone, is it sufficient or is the legislative amendment essential? So if as committee we want to put in our own suggestion in terms of a bill, the steps that the committee needs to take in terms of the rules of parliament, is it sufficient? Secondly, my second question will be, what is the committee's capacity to initiate and process a committee bill within the current legislative cycle? And also the third one, is it urgent to address the ambiguity, or can it be included in a broader amendment bill to the Basic Conditions of Employment Act? Thank you very much, Chair.
Thank you, Honorable Mupeli. Honorable Oso, let's welcome you once again.
Thank you very much, Chairperson. I would like to welcome the presentations done. 2 weeks ago, we had an employment forum where I had the privilege of sitting in. And this actually came to the House because the employer said, it is my choice to decide on which scale I pay you, because it does not specify. And I would be extremely happy if we can change this to specify it better. I do think that if you work on a public holiday, you are entitled to more income, and you are entitled to the correct form of income, because you are giving up free time with your family, with your loved ones. So this bill to me is very close to the heart, because I was in a conversation where we had this matter, and at the end of the day, the employee could not fight it because the bill now leans towards the employer, as the wording and the pronoun is not correct. So I welcome and I thank this presentation. Thank you, sir.
Thank you, Honorable Basson. The Honorable Bahrain, I've jumped to, sorry.
Thank
Yeah.
you. Yeah, no problem. I have two issues. Obviously, the first one is, yes, the wording is probably incorrect. And secondly, the litigation arising out of that in the past has been nil. It's actually quite weird because I've been in that litigation with the interpretation of the Basic Conditions of Employment Act for almost 30 years now. Now, what the real devil is in the detail, and we always say that. The reality again over here is, how are you going to word it so that it is absolutely crystal clear? I'm still not so sure that the wording that you've proffered is crystal clear, and it will have hundreds of judgments arising out of this in due course. The one issue that we need to clear up absolutely once and for all is, when a public holiday falls on a Sunday, we then have a public holiday on the Monday. Now, we need to define that they're both public holidays or only one is a public holiday, because we all know you're entitled to get overtime on a Sunday, but if you ordinarily work on a Sunday, you get 1.5 times. If the public holiday is then deemed to be on the Monday, then you're going to get double. Or are they both public holidays? And that's been an issue, and that has arisen. And quite frankly, I've been advising employers over the years that choose one to pay double and the other one to pay 1.5. And we need to clear that up as well. The problem that we've got is when you actually put documents together and you're saying that let's look at the syntax, let's look at the structure of the sentence, there are going to be dozens of interpretations thereafter. So let's keep it simple. Thanks.
Honorable Bahrain, Honorable Mpele.
Okay, thank you very much, Chairperson. Let me greet yourself, Chairperson, and the members, the honorable members, and the officials, senior officials that are here. I don't know if the ministers are here. If they are here, I also greet them as well. Chairperson, actually for me is the clarity, because I'm grappling to understand this issue of the greater in terms of the, I think it's, what is it? Is it 18B2, something like that, the clause of basic conditions of employment. Now, the greater, what does it mean exactly? Because I want it to be simplified. It's either maybe, let me just say, on a holiday, I'm supposed to be paid for that day. Let me just say 200 rand. Then when you say it's double, that means I will rate on that day 400 rand. Now, if it's greater, does it mean maybe if the employer decides to pay me more than that, is more than that 200 extra? Let me just say it's 200. Yes, it doesn't have a question. And then you've got another 200, which is going to make 400. Maybe the employer says, okay, right, I'm going to pay you 300, which can come to be 500 rand on that day. So what does this greater means exactly in a very simple language? And I think the other one is this one of the, but the latter speaker has already raised it. I also wanted to check this thing of Sunday. What do you call it? The Sunday, is it a double pay? Because as far as I'm concerned, I also agree that on Sundays, people is their family time. So if people are working on a Sunday, is it regarded as an overtime or and it's supposed to be or as a public holiday as well to get a double pay? Yeah, but at the same time, I really applaud that this area, this amendment, at least they have improved the lives of the people. It's going to improve actually the lives of the people because these employers have been very cruel to our people. So, but I would need to get that. The other one, Chair, if maybe it was physical, I was going to take this one in bilateral with the officials, but unfortunately I'm here because I also came across with an issue of one of the employees was employed, which was when she was employed, they said she was an administrator, but the money she was getting paid, it was very high. She was getting something like 80,000, if I'm not mistaken, a take home. And then now, I don't know, they found that this lady was working in the municipality. Now, she's got a case that they have cut their money. I don't know, they are saying there's a regulation in terms, the salary scales, it's regulated based on your qualifications. So I would want that to be cleared. Now she's got that case. Is it a winnable case or what? I don't know. Maybe they can advise me on that one. So because even myself, I was just caught up into the middle of this because I didn't know, because yes, even for me, I was questioning the salary, so much salary, which is more than 80,000, which is a take home. But a person is an administrator. Does it really qualifies the salary? And based on the qualification a person has, you see, because they just found it, the auditor actually picked it up. So now they have to respond, they have to rework the salary scale. So can you also assist me on that? I know it's not on the agenda, but because we're on online, so I'm sorry, Chair, about that. Thank you so much.
Thank you, Honorable Pele. At least you do know when you're out of order. But I allow you to raise what comes from the constituents, because I will also respect the work parliamentarians do. And I'm sure on this aspect, like you said, you were going to do it sideline. I think there can still be a response in that regard, so that we are, from a point of relevance, look at the matter that's before us. And I'm sure the department would have taken note and they'll make that contact. But of course, it doesn't take away the points we've made on the matter that's on the table. As I recognize you, Honorable Nansele, as the last one.
Morning, Honorable Chair. Can I keep my video? But there is absolutely nothing untoward on my side. I'm just a normal human being. It's just to extend my bandwidth. Morning again to you, Honorable Chairperson. Morning to honorable members. Also morning to members of the department as led by the Deputy Minister and the all protocol observed. Honorable Chair, let me first welcome the presentation as presented by the Parliamentary Legal Committee. We appreciate the input that has been made, particularly with regard to the areas that honorable members have already alluded to, so that there is certainty with regard to how the section dealing with double time is in fact framed. Yeah, but there's just few points, Chair, that I want to raise. The first one is with regard to the fact that we currently are busy engaging with the department regarding amendments to the very same piece of legislation, that is the Basic Condition of Employment Act, which basically would mean that we would need to find a way to align these processes so that we don't have to do a back and forth exercise. You have the committee on the one side running its own way, and then you have the department also running its own way. So my suggestion and proposal, Chair, is that we should seek to streamline the two processes so that we then are able to ensure that by the end of the exercise, we have a single document that has been carefully worded on the one side, but also with the necessary amendments that are currently underway. The second point, Chair, is with regard to the ongoing processes at NEDLAC, which have been topical to our constituencies, which the department in particular has been championing or leading. There's quite a lot of interest to get through those proposed amendments. As we all know that we have been subjected to all manner of speculation with regard to what the amendments say on this or say on that. Then what this means, if, for instance, we again run two parallel processes, it would mean that we would, in fact, add more confusion to society and not help focus everybody into a single direction, that is with regard to the already initiated process that is led by the department and also the one that we're proposing now. The final point here is with regard to the outstanding issues, including those that were lifted in 2018 by the then commission led by the then president of the country, His Excellency President Mutlande, which also made some observations with regard to the deficiencies within the very same piece of legislation, that is the Basic Condition of Employment Act, meaning that there's quite a lot of areas that we may have in fact left behind and have not taken note of. And as a consequence, this in fact comes at a time when we should in fact be seeking to consolidate all the work and ensure that all the issues relating to this piece of legislation, that is the Basic Condition of Employment Act, are in fact dealt with, and that if there are any areas that in fact are challenging, then they are dealt with more efficiently. The point, therefore, that my proposal is to accept in principle the presentation by the Parliamentary Legal Service Committee, and then but propose that we should in fact also, as part and parcel of this discussion, bring on board the department so that we have a more integrated approach, so that we do not run with one process and then immediately thereafter introduce another process, but we seek to integrate the processes, because at the end of the day, each exercise would need the other side to also to input and to participate. So, but if we integrate these processes, then it's much more easier for us to move forward in a more focused way. And also the issue of time, that would need to take also the process in a manner that in fact does not in fact delay any of the intended processes, and that we should be able to conclude it within reasonable time, so that we give certainty in the areas that is of ambiguity, whilst on the other side also giving concrete responses as the Parliamentary Committee with regard with the proposed amendments that are coming, that is by the way of the department. So that's my proposal, Honorable Chair. I hope that it has been well understood. Thank you, Chair.
Thank you, Honorable Nanzeli, with the last. I understand there may be pressures with time, but we must allow the responses. But maybe before I do that, because there was a specific question that relates to the department, whether they think they would want to give a preliminary response now, or at least take the point that they will have the opportunity to come before the committee. At least they have first-hand presentation, so they have enough time to go back, look at that. I take it to be the understanding before I give to the Constitutional and Legal Services Office. Okay, then let's give to yourselves, Ms. Hali and the team. Thank you.
Thank you, Honourable Chair. So I'll start off with Honourable Maiko's question with regard to whether the wording would warrant that much ambiguity to warrant an amendment. And I think Honourable Basson and Honourable Bagram's response or questions illustrated that there is ambiguity, although there being no litigation on the matter. It is open to various interpretations, including that of Honourable Mbele, who also could not understand the what does the greater mean. And seeing that I am dealing with Honourable Mbele's question, Honourable Mbele, what the section is trying to say is that you can either be paid as an employee double your wage, or you can be paid what you would normally get on that day, and then plus whatever your employer would have paid you extra. So whatever is greater of those two. And I think that in itself answers your question, Honourable Maxwell, that there is ambiguity as to what is the greater. That leads me to the question regarding the pronoun. Is it open to misinterpretation? Yes, as I said, it was. And what is the department's interpretation? I think that can be left up to the department to respond to, either today or if on a later stage. Honourable Mokwela, you requested to know whether our oversight alone is essential, or could we then perhaps create other suggestions? And this is all part of the committee bill process. At the end of the day, with the committee bill, the committee owns the process. So this also touches on what Honourable Bagram had said about whether he wasn't entirely sure whether our suggested amendment would satisfy the ambiguity or the confusion in syntax. And that is entirely correct, Honourable Bagram. That's the brilliance of a committee bill process, is that the committee owns the process, and that following the process, which my colleague Clara Williams can touch on further, there is an opportunity for public submissions, it's an opportunity for experts in the field to provide insight, and obviously to get a more clearer and less ambiguous section. As you said, the devil is in the detail. And I think there was a question from, I think I handled most of the questions regarding the actual amendment. There was a question from Honourable Mbele about a case that she had. If you have any other questions, and it is the committee's decision to take a legal question to legal services, we have an advisory unit that can answer that question in more detail. I think it would be untoward of me to answer a legal question of that nature in a committee meeting where I don't have the full details, but I'm sure you can appreciate that. And I'll hand over to my colleague Clara Williams if I missed anything regarding the committee bill process. Thank you, honourable members.
Thank you so much, Honourable Chairperson and Honourable members. Yes, I just want to reiterate that it is the prerogative of the committee to decide whether to continue with the oversight functions with regards to an executive bill that is in the making at this point in time, or whether to develop its own committee bill. With regards to executive bills, it should be noted that there is a process that needs to be followed by the department before introduction in Parliament, and that is also a timeous process. But as I stated, it is a prerogative of the committee to decide how to proceed with this matter. We aimed to inform the committee this morning of the lacuna in the Basic Conditions of Employment Act that we identified, so that the committee can then make an informed decision on how to proceed. Thank you so much.
I'm not sure, Honourable Mayetso. I suspect it is a legacy hand.
Yes, Chair, it's a legacy hand, Chair.
Okay, I just want to be sure that I don't leave anyone behind. Like I said, the department has a choice whether on that specific question you would want to respond now or at the time that we call you to come before the committee, so that the responses are also well informed from also your experiences in the practical execution of work in fulfilling the spirit and intent of the law, as we now see the gaps. Mr. Kalipi, the DTG, I see your hand. You can come in.
Thank you, Chair, and honourable members and colleagues. The issue raised, it's a technical issue, and we think it can be dealt with. And just for the benefit of the members, the intention of the initial intention of the EAT and TREE was to make sure that if you get paid, you work more than the hours that you were supposed to work. Let us say A says if you work 9 hours a day and you don't work on a public holiday, you must be paid for those 9 hours. And then B says if you do work on a public holiday, you must be paid double that 9 hours that you work. And then B1 says, if you work on a public holiday and the hours that you've worked are more than what the amount that is in B, let us say you work instead of 9 hours that day, you work 15 hours. Therefore, you must be paid the money that you're supposed to be paid in A, double the money that you're supposed to be paid that are extra than the normal working hours. That's the intention of the law as it stands. And we agree that it can be made clearer. And there's been no case, our take is that the labor market understand what's the intention of this section. There's been no confusion, no case at all at the CCMA where workers say they've not been paid correctly, inspectors where workers say they've not been paid correctly. But that doesn't mean that there are no future cases that might come. Therefore, we don't have an issue, an objection in correcting the issue. But we are in line with the proposal that is put by Honorable Nongele, that says that we should consolidate these amendments. We are already on the final line now on the amendment. We've already received a certificate of the BCEA. We are incorporating these changes that now are being discussed so that when we come in here, they are already incorporated. We're waiting for a certificate for LRA so that the intention is to bring all of them at the same time, because at the NETLEC, there was a give and take in these bills and negotiated as one group. Now, we don't want to bring the LRA, the BCA, bit by bit. We want to bring them, all of them, so that the balance that was created at NETLEC and agreed by parties in terms of the give and take that was there is not lost. But in terms of the proposal that is made, it's a technical proposal that is made. It might make it easier if there's more clarity on this issue. But as the papers indicate, there's been no issues about this area. But that doesn't mean that in future there might be no issues that we need to clarify it on. Therefore, if there's an opportunity to clarify it and make it clearer, we wouldn't have any objection to that. Thank you, Chair.
Thank you, DDG, Mr. Kalipi, for that response, and it helps clarify members at least what is the status quo in terms of cases that relates to the clarity to be made. Honorable members, I would want to indicate that at least from the responses and the questions that you would have asked, there is an understanding that there is acceptance that the clarity is needed, but it doesn't change what the intention of the law would have been, except to make sure that there's no ambiguity. It may not be a case now, but prevention is better than curing it at the time that a case would be on our table when this matter could have been seen up front. So the other point, it's an agreement that would have to call the department, but there's already a commitment from the DDG that because this is a technical amendment, it should be easy to accommodate. And I'm sure members would accept the point that indeed it's important to bring all these laws in line, because you may make an amendment now in a piecemeal approach, but it may have implications for others. So you have to really check all that, so that amendments must be in a way complementary in realizing the intentions of the law than contradictory in a way. So with that, honorable members, I would want to really thank the team for also responding quickly when we said they should come before us and present. But also, in a way, thank you, honorable members, for an understanding that in between your preparation for speeches, you will prioritize this important work from this committee as lawmakers. And I think from this, at least the first, that the recommendations will be now taken forward, which starts with the one of inviting the department to come before us, and that would make the necessary arrangements to do so. So having said that, I would not want to keep you further, and only to say that as we close and attend the meeting officially, I did see a member visiting the committee, unless something else has happened. Honorable Slepe, the meeting is officially adjourned. We will see each other again. Thank you. Meeting adjourned.
Thank you, Chair.
Welcome, Honorable Slab.
Don't say out of order. Why?
Commander.
Remember,
Yo, I'm so sorry. I'm in a
we are out of
plenary.
order.
My friend, the chairperson was looking at you.
Yo, Chairperson, guys.
Slepe, take it easy, my brother. We'll see each other.
Where's Mkwanas?
Thanks.
Thank you.
Thanks,
Bye. Thank you
Thank
so much. Yeah. Mhm.